My name is Rachel Koss. I'm here on behalf of Safe Fuel and Energy Resources California. Our comments on the draft EIR and revised draft EIR included hundreds of pages of detailed technical analyses and calculations from independent air quality and hazards experts with decades of experience working on refinery projects. Our comments show, among other problems, that the EIR at every corner underestimated the project's emissions so as not to find significant air quality and public health impacts. But our comments provide substantial evidence that the project will result in significant air quality and public health impacts, both within the refinery bounds and beyond, and within the BACMed and every single uprail air district. The final EIR largely dismisses our comments. It responds with a few pages of unsupported conclusions. Basically, it says in most instances, oh, just look at our EIR. We did it right there, our draft EIR. It's right. The final EIR doesn't come close to complying with CEQA. But tonight I want to talk about preemption. Last night, Mr. Hogan presented his take on the issue. Simply put, Mr. Hogan is wrong. Mr. Hogan incorrectly framed the legal issue in this case. This issue is crucial, and the city has to get it right. Case law says that permitting and preclearance requirements that could be used to deny a railroad the ability to conduct its operations or to proceed with activities the Surface Transportation Board has authorized are preempted. Mr. Hogan argues that the city's permit fits in this box, that the city can't deny the use permit for the project because that would be the city denying Union Pacific the ability to conduct Union Pacific's operations authorized by the STB. Mr. Hogan is saying that the city's permit fits into a box of something that has already been authorized by the STB. That's not the box we're in here. We are in the city's use permit box, the box where the city must authorize a use permit for Valero's project. This is not UP's project. The STP doesn't authorize Valero's use permit for this project. That's the city. To put it another way, because I really want to make this clear, Union Pacific is not the applicant, Valero is. The use permit for Valero's project is not a permitting or pre-clearance requirement imposed on Union Pacific, as Mr. Hogan would have it. So the first step in the preemption analysis is, does the city have authority over the use permit? Yes. Valero's permit requires a use permit under the city's code, and the city is the only agency with authority over the permit. The city, not the STB. If the city has jurisdiction, and it does, the pre-clearance inquiry ends right there. The only preclearance requirement is the one placed on Valero by the city. If Valero doesn't get its permit, Union Pacific goes on business as usual. The project, at this point, it's just a proposal. It hasn't been approved by any agency. The project is certainly not a part of Union Pacific's existing operations. So now I've established the project's not categorically preempted. The next step is in the preemption analysis is to determine whether the city's action would unreasonably interfere with rail operations. And case law clearly shows environmental regulations or similar exercises of police powers relating to public health or safety, unless the action is discriminatory or unduly burdensome, are not preempted. That means cities like Benicia can exercise its traditional police powers to protect public health and safety if the regulation does not burden rail operations. So, it's the city's right under the Constitution and obligation under CEQA to protect public health and safety and the environment from the adverse effects of this project, so long as the city doesn't unduly rail operations by its action. That burden question, it's a factual question. In this case, requiring Valero to pay money to offset emissions has nothing to do with Union Pacific's operations. That's an example. Union Pacific is going to go on status quo with its operations. Mr. Hogan doesn't even want you to get to that question. He's saying off the bat, you can't analyze that factual question.
My name is Jackie Prang, and I'm a staff attorney at the Natural Resources Defense Council. I know it's a late night, so I want to kind of get straight to the point. We have commented extensively about the inadequacies in the EIR. I'm not going to go through all of those. Our latest letter, which we submitted yesterday, is very short and kind of highlights the main problems in the EIR, and it's only about 5 pages, so not too heavy of reading. I know you have a lot to read. Tonight I'd like to focus on the preemption issue, since there's been a lot of confusion and debate and discussion about that issue. And specifically on the Interstate Commerce Commission Termination Act, or ICTA, as those of us who have to deal with this law all the time is referred to. In the staff report on page 35, it states that the benefits of this project do not outweigh the significant negative environmental impacts, but basically that the city's hands are tied and that it has to approve this project. Quite frankly, I've never seen a conclusion like that in an EIR or in a staff report regarding a project under CEQA review. And we disagree with that analysis. The city can deny this project. Valero is not a rail carrier. And just to quote, that is defined specifically under ICTA as a person providing common carrier railroad transportation for compensation, a common carrier. Valero is not a common carrier, and I don't think there's any dispute really about that. Mr. Hogan admitted that much. And he also agrees that whether or not a project proponent is a rail carrier is a very important distinction. And there's a reason Congress drew the line there. Commissioner Young, you brought up the example of a landfill. That's a perfect example. The city retains traditional land use authority to deny a landfill. Joe or Jane Schmo can't just go in and put in a landfill and say, you can't do anything about it simply because I'm having the garbage shipped here by rail. I think where we differ from in our analysis of the law from what's in the staff report is the reasons why the city can deny the project. The staff report says the city can only deny the project for non-rail related reasons. I'm not aware of any authority that constrains the city in that manner. And indeed, your colleagues over in San Luis Obispo came to the same conclusion. So we're not the only ones saying this. But I think the most important point is, even if that's true, that you are constrained and you can't cite rail reasons as for the reasons for denying the project, there are a lot of other impacts that have nothing to do with rail here. We've outlined a lot of them in our letter, primarily air quality impacts having to do with the refinery. Now, I know those aren't adequately analyzed in the IR, so you're a little bit tied up there, but they certainly are and will be significant. Unloading, emissions from unloading, and other dangers from unloading the crude. And finally, impacts to local creeks, other impacts that are going to happen on site. Your attorney has basically given you free rein to look at all of those reasons to deny the project, and I suggest you do that. So in sum, the city can, should, and indeed must, as a legal matter, deny this project and decline to certify the EIR.
Good evening. I'm an attorney with the Sierra Club. We have over 145,000 members in California, many of whom would be impacted by this project. And we've submitted, along with our allies, several comment letters during the environmental review process. And as we've explained in these letters, the EIR for this project is inadequate under CEQA, and the project is also inconsistent with the general plan and your municipal code. According to the staff report in the EIR, the project would have 11 significant and unavoidable impacts related to rail. We disagree that these are the only significant impacts from the project, that none can be mitigated, and that you can't even consider these impacts. Nothing in federal law preempts the city from declining to certify the EIR and denying the use permit for the project, including denial based on these rail impacts. In fact, CEQA requires consideration of these impacts. To quote the statute, the lead agency shall be responsible for considering the effects, both individual and collective, of all activities involved in a project. So nothing in federal law requires that you abandon these principles under CEQA, simply because the federal government plays a role in regulating railroads. It does not mean that the states and local governments are powerless when an oil company's project involves rail. As you know, in October 2014, the Attorney General of California submitted comments on the draft EIR for this project. The very first comment in that letter was that the draft EIR failed to adequately analyze the project's impacts to up-rail communities. The AG found that the draft EIR violates CEQA by not analyzing these foreseeable impacts. The Attorney General faulted the draft EIR for giving, and I'll quote, little consideration to the potentially serious, even catastrophic impacts that a release of highly volatile and flammable crude oil would have on communities and the environment, end quote. These are the serious catastrophic impacts that you are now being told you are legally required to ignore. And I know you're aware of the San Luis Obispo Planning Staff Report. Also, I would point you to our comment letter dated February 8th, which lays out some of the relevant case law. And you also heard from the gentleman from Davis about the Sacramento area government letter that lays out some of the relevant law as well on preemption. So I urge you to reject this idea that you cannot consider these impacts or deny this proposal based on the significant unavoidable rail impacts. But even if you were to accept this position, that federal regulation precludes both imposition of all mitigation measures along the rail line and precludes even taking the rail impacts into account in your decision-making, a position that has no solid basis, regardless, there are other impacts separate from the rail impacts that require denial of this permit. And I just want to discuss a few of those right now. The first involves air quality as relates to the refinery emissions. The project would increase the refinery emissions by increasing refinery throughput, because the proposed reduction in crude from ships is not an enforceable condition of approval. The project would increase emissions by increasing the proportion of dirty and volatile crudes being processed. There would also be air quality impacts from non-rail transportation emissions. The project would not reduce ship traffic at the port, so there would be no offset of marine transportation emissions. Construction impacts, air quality impacts from that. Environmental justice, the project would have a disproportionate impact on low-income communities and communities of color due to the increase in refinery emissions. The project would pose a significant hazard risk due to the risk of a spill or accident during the offloading process or other activities. And all of these I'm referring to on Valero property, not up-rail impacts. The project would pose a significant risk to water quality and risk to wildlife, especially in the Sulphur Springs Creek riparian corridor, due to the possibility of spills during the offloading of crude or other activities on Valero property. The project would have significant noise impacts due to unloading and other activities on Valero's property. Under the Benicia Municipal Code, the Planning Commission cannot approve a use permit unless it makes several findings, one of which is that the proposal will not be detrimental to the public health, safety, or welfare of persons residing in or working in or adjacent to the neighborhood of such use, nor detrimental to properties or improvements in the vicinity or to the general welfare of the city. So for the reasons I've already explained, I think both those impacts related to rail and not related to rail, the project would be detrimental in those ways. And I'm running out of time, but I'll just say that there are a lot of inconsistencies with the general plan as well, involving both rail and non-related impacts, rail and non-rail related impacts. And I direct you to the letter that NRDC submitted this afternoon. Thank you.
My name is Claudia Antonacci. I'm here with the Stanford Mills Legal Clinic on behalf of the Center for Biological Diversity. And I apologize, the lawyers are a bit stacked up here at the end. I'm also here to talk about federal preemption. So the staff report before you today finds that the project benefits don't outweigh its significant and unavoidable impacts. Yet the report nonetheless concludes that the city has to lie down and accept Valero's proposal because the ICCTA preempts the city from denying the project based on its rail-related impacts. In presenting this issue to you on Monday, the City Council characterized federal preemption as a settled, black and white area of the law. It's not. It's a complicated, fact-specific issue that must necessarily begin with the Supreme Court's preemption precedent. But the staff report and the City Council failed to walk you through that precedent, a precedent that's been carefully crafted to preserve the federal-state balance on which our country is built. And that precedent plainly shows the staff report and the City Council's conclusions are wrong. As an initial matter, there's two forms of federal preemption, express and implied. Express preemption occurs when Congress clearly conveys its intent to preempt a particular exercise of state law. Implied preemption, on the other hand, occurs when state law stands as an obstacle to the goals Congress sought to achieve. In assessing the existence and scope of any federal preemption, courts are guided by two cornerstones of preemption law. First, Preemption is fundamentally a question of congressional intent, namely, what range of activities Congress sought to sweep into its orbit. Second, preemption analysis always begins with the presumption that states and localities retain their historic police powers. The ICCTA does not expressly preempt the city's traditional land use authority or environmental review laws. What the ICCTA does expressly preempt are local remedies with respect to the regulation of rail transportation. But the city's use permit and responsibilities under CEQA don't regulate rail transportation. Instead, they're generally applicable background laws that are directed at community health and welfare. Congress did not intend to displace these traditional local health and safety laws in passing the ICCTA, a statute that's primarily aimed at economic regulation of railroads and fairness of the interstate rail system. Hence, the ICCTA does not result in express preemption of the city's authority. And for similar reasons, it doesn't result in implied preemption of the city's authority. The city's land use and environmental review laws are intended to protect the community health, public safety, and the environment from the impacts of land use activities, regardless of who's proposing them. They don't target the railroads, and they don't frustrate Congress's purposes of a fair and economically sound rail industry. Rather, they're tools that the city can use to protect its land and citizens. To deny the city the right to use these tools is to strip your quintessentially local authority over health and safety. Federal preemption law, as dictated by the U.S. Supreme Court, does not allow this result absent a clear congressional intent that is entirely lacking in the ICCTA. Finally, in this case, the staff report's preemption conclusions are particularly misplaced due to the nature of the proposed project. The project at issue here is an exclusively private rail spur and unloading facility that's going to be constructed and operated on non-railroad land for use exclusively by a non-railroad carrier. The ICCTA is virtually irrelevant for this purely local facility because it is only concerned with transportation by rail carriers. Valero is a private oil refinery, and it does not meet the definition of a rail carrier because it's not providing common carrier services to the public. For these reasons, among others, the ICCTA does not have the exceedingly broad reach that several have contended that it does. Thus, Valero can't escape local oversight, and the city can't skirt its responsibilities to regulate simply by claiming that the project's rail-related impacts deprive the city of any meaningful control. Thank you.
Thank you. Next speaker is Rayleigh Kircher here. Good evening.
Good evening, Commissioners. My name is Riley Kircher, and I am also here with the Stanford Mills Legal Clinic on behalf of the Center for Biological Diversity. I'm going to discuss 3 ways the staff report mischaracterizes the scope of federal preemption and the city's corresponding permitting authority. First, the staff report incorrectly claims the ICCTA's preemption language prohibits the city from even considering off-site impacts that directly flow from the project. As my colleague explained, the ICCTA has nothing to do with this private, non-rail carrier facility at the project approval phase. Thus, the city is required to consider all potential project impacts, including off-site impacts. CEQA guidelines specifically state that the city must consider all direct, indirect, and cumulative impacts, including those impacts further removed in distance from the project. In this case, those impacts undoubtedly include effects along the Union Pacific Main Line. And while the city is likely preempted from imposing mitigation directly on mainline rail operations, it certainly is not required to ignore the impacts of these operations altogether. In contrast to the ICCTA, some federal acts do contain language expressly preventing localities from considering particular issues in fields heavily regulated by the federal government. For instance, the Telecommunications Act specifically prohibits localities from considering the environmental effects of radio waves when regulating wireless facilities. The ICCTA, however, contains absolutely no language preempting consideration of impacts. Therefore, the city must consider all impacts, including off-site impacts, in reaching its decision. Second, the city has full authority to deny the project based on the environmental health and safety concerns caused by on-site and off-site activities. Denial need not solely be based on impacts at the project site. For instance, denial can be based on the 11 significant and unavoidable impacts identified in the environmental impact report, even if the impacts are due to rail operations. The city also has authority to deny Valero's application based on the health and safety risks posed by rail operations, as well as the use permit findings related to off-site aspects of the project. The staff report is incorrect that denial can only be based on non-rail impacts. To the contrary, if the city agrees with the staff that the benefits of the project do not outweigh the unavoidable significant impacts, the city must deny the project. Third, if the city instead decides to approve the project, it has the authority and responsibility to require Valero to take reasonable mitigation measures, even if those measures incidentally affect transportation by rail carriers. For example, permit conditions directed at activities and operations on site are not preempted by federal law. Everything is related to everything else, so of course mitigation measures imposed on Valero will have consequences on railroad activities upstream, just like it will impact other related activities, like marine shipments and oil production. While the city cannot impose measures directly on Union Pacific, it is not preempted from regulating what happens on non-rail carrier land. Since the Federal Surface Transportation Board has no authority to regulate the construction or operation of Valero's proposed project, the city must be able to regulate, or there would be absolutely no oversight of private construction related to rail activity. Congress did not intend to create a gaping hole in regulatory authority when enacting the ICCTA. In conclusion, the city, 1, must consider all project impacts, including off-site impacts. 2, has the authority to deny the project based on these impacts. And 3, if the city does mistakenly approve the project, it must make the required use permit findings and impose mitigation measures as required by law. A rail spur and unloading facility is a local development project just like any other, and the city has the authority to decide what gets built in its community. There is no reason for the city to voluntarily and incorrectly restrict its governing powers. The city has a responsibility to regulate local land use decisions, and if the city doesn't properly use its authority to speak up on behalf of its citizens, no one will. Thank you.